This is the first of 2 lectures on self-induced intoxication. In this lecture, I discuss the circumstances under which self-induced intoxication can negative the fault requirement for a given offense. Let's start with objective fault offenses, because this is pretty easy. Remember that in Creighton, Madam Justice McLaughlin was clear that the reasonable person simply does not engage in regulated activities while intoxicated. It therefore follows that one's self-induced intoxication is irrelevant in the context of objective fault offenses. Quite simply, the fact that one was too drunk to adhere to the standards of the reasonable person can provide no basis for an acquittal. Matters, of course, get somewhat trickier when we turn to subjective fault offenses. Intuitively, of course, the fact that one had a bit too much to drink or had consumed drugs ought to be relevant to whether or not one turned one's mind to some relevant circumstance or consequence. And to that extent, one would expect that one could adduce evidence of one's self-induced intoxication by way of negativing the fault requirement for a subjective fault offense. Matters, of course, are not quite so simple. Whether or not one can consider self-induced intoxication as a basis for negativing subjective fault will, in the end, depend on the kind of offense we're talking about. In particular, we have to introduce a distinction that so far we haven't needed to talk about in these lectures. And that's the distinction between general intent offenses and specific intent offenses. Where we are dealing with a general intent offense, one's self-induced intoxication simply cannot negative fault. Period, full stop. Where, on the other hand, we're dealing with a specific intent offense, it can. Now, this distinction between specific and general intent is a distinction devised specifically to cope with the problem of self-induced intoxication. It's the only reason we care about this distinction. In principle, the distinction between specific and general intent offenses is conceptually drawn on the basis of the level of mental acuity required to commit a given offense. Some offenses require only an intention to commit a particular act, say assault, sexual assault, which require proof only of an intention to apply force. Other offenses require proof of an intention to commit a particular act for a particular purpose, or in the knowledge of some state of affairs, or in the knowledge that some consequence may ensue. For example, murder or robbery. Now, the former we describe as general intent offenses, because these require proof of relatively little mental acuity. The latter we describe as specific intent offenses, because this requires proof of a somewhat more complex line of thought on the part of the defendant at the relevant time. The supposition is that with respect to general intent offenses, those offenses requiring relatively little mental acuity on the part of the defendant, that the mental acuity required is so simple or basic that even a heavily intoxicated individual could reliably achieve it barring intoxication to the point of automatism, which we'll talk about in the next lecture. By contrast, the mental acuity required for specific intent offenses is sufficiently complex that one's self-induced intoxication, it's said, can call it into question. Now, at risk of stating the obvious, the question is whether or not this offense with which the defendant has been charged is one of general or specific intent, and not whether this offender deserves to be punished. We are engaging here, the focus here is very much on, again, statutory interpretation. We are asking whether or not this offense with which the defendant was charged is itself one of specific intent or general intent. If we conclude that it is an offense of specific intent, then evidence of the defendant's self-induced intoxication may be admitted by way of negativing fault. If it is an offense of general intent, then evidence of the defendant's self-induced intoxication is simply irrelevant. Now, where precedent has already determined that a given offense is one of general or specific intent, we can, happily enough, regard the matter as settled. But where precedent has not resolved the matter, we need to look to two considerations. First, what mental element has been set out by Parliament for the offense in issue? And second, would it be contrary to public policy to characterize the offense as one of specific intent and therefore allow the accused to rely upon a defense of self-induced intoxication? On the first point, the mental element of the offense in issue, we might ask questions like, has Parliament made ulterior purposes part of the offense? So, for example, the offense of assault with intent to resist arrest. There it isn't enough to establish an intention to apply force. One must also show an intention to resist arrest. That suggests that proof of an ulterior purpose is required and that greater mental acuity on the part of the defendant is necessary. And that, in turn, we will be readier to infer that Parliament took the view that, yes, self-induced intoxication can indeed negative fault for that offense. What other sorts of mental elements might demonstrate that Parliament thought that greater mental acuity was required? Well, maybe the offense in issue requires an intention to bring about certain consequences. For example, the offense of murder. We might ask questions like, to what extent has Parliament imposed additional knowledge components? So to what extent does one need to know of certain circumstances in order to commit this offense? To the extent those additional knowledge components are there, again, greater mental acuity. Now, if an examination of the mental element of the offense doesn't provide us with a clear signal as to whether or not Parliament intended this offense to be one of specific intent or general intent, then we're going to need to turn to that second stage, policy considerations. What sorts of questions are we asking when we consider public policy? Well, we need to keep in mind that it would be absurd to suppose that Parliament intended to devise an offense for which self-induced intoxication could be a defense, when the offense itself is typically or frequently committed while in a state of intoxication. Why would you make it an offense to engage in this course of action, which people typically engage in while drunk, and then say in the same breath that if you're drunk or high, that we will acquit you? The answer is that Parliament wouldn't do that, or we wouldn't certainly expect it to. And so, to the extent that the offense in question is typically associated with, as it were, intoxicated offenders, we're going to be more likely to proceed on the basis that Parliament didn't intend for self-induced intoxication to negative fault. Furthermore, we might consider whether there is a lesser included offense that is one of general intent. If so, there's less risk that self-induced intoxication will lead to an outright acquittal, and so less reason to regard the availability of this negative defense as absurd. Now, just to be clear, this public policy line of argument isn't supposed to override the analysis of the mental element that we did in step one. That, it's quite clear, is meant to drive our analysis for the most part. All of this talk about public policy is really by way of settling the matter in cases of real ambiguity. Now, the Supreme Court applied this approach to determining whether or not an offense is one of specific or general intent in a case called Tatton. And Tatton focused on section 434 of the Criminal Code. And that provision states, every person who intentionally or recklessly causes damage by fire or explosion to property that is not wholly owned by that person is guilty of an indictable offense. And in Tatton, the court looks at the language of section 434 and finds that, well, look, the level of mental acuity required to intentionally or recklessly cause damage by fire or explosion is pretty minimal. One need only turn one's mind for a moment to the risks associated with a fire or an explosion. So fairly minimal degree of mental acuity. And that by itself, the court in Tatton suggests, is enough to lead us to conclude that this offense is one of general intent, and that therefore evidence of self-induced intoxication is really gets you nowhere by way of exculpation. In Tatton, Mr. Justice Moldaver, writing for the court, states, "I have difficulty seeing how intoxication short of automatism would prevent an accused from foreseeing the risk of causing damage to someone else's property by fire. Complex reasoning is not required to recognize the danger. Thus, preventing an accused from advancing the defense of intoxication does not transform recklessness into an objective inquiry. Rather, it recognizes the fact that intoxication short of automatism will not deprive an accused of the minimal intent required for this crime." Now, as I say, the court is able to reach this conclusion in Tatton essentially on the basis of the mental element set out in Section 434. However, the court's also clear that had it needed to consider policy factors in determining whether this offense is one of general intent or specific intent, well, it wouldn't have changed the outcome, because damage to property is often associated with alcohol abuse. Now, Tatton, and indeed the entire distinction between specific intent and general intent, to the extent that we are relying on this distinction to determine whether or not criminal defendants are even entitled to adduce evidence of self-induced intoxication and attempt to negative fault by adducing that evidence, is highly controversial. And we can see why this is all controversial just by even turning to the facts in Tatton itself. In Tatton, our defendant is very drunk. He places a pan with oil on the stove, sets the burner to high, and then leaves the house to go and get some coffee. He returns 20 minutes later and finds his house on fire. The trial judge concludes that this offense is one of specific intent. So, contrary to what the Supreme Court ultimately found, considers the defendant's state of intoxication and acquits, finding that the defendant's state of self-induced intoxication was such that he never even considered the possibility, never even considered the risk that his conduct might cause any damage to property. Now, we know, as I say, that the trial judge was wrong to find that this offense was one of specific intent. Following the reasoning of Mr. Justice Moldaver in Tatton, we now know that this offense is one of general intent. And so we might think, no surprise that the Supreme Court orders a new trial. But wait, think about this for a moment. So we're going to have a new trial, and what's going to happen at the new trial is that the defendant whose self-induced intoxication earned him an acquittal at the first trial won't be able to adduce evidence of his intoxication at the second trial. And the trier of fact will be unable to consider even the possibility that the defendant lacked requisite fault on the basis of his drunkenness even though at the first trial it was found that that state of drunkenness was enough to negative fault. So we're actually, in a sense, in a very real sense, depriving the defendant of a defense that had succeeded at the earlier trial. And what we might well wonder is, who cares whether or not an offense is one of specific or general intent if the defendant's state of self-induced intoxication actually negative the negative fault? We may well ask whether or not it's fair to assume that non-extreme intoxication is never a factor capable of undermining the minimal degree of awareness or intent needed for a general intent offense. We might well ask whether it's reasonable or fair to deny all defendants of the opportunity to at least make the argument in a given case in which they've been charged with a general intent offense. Now, in a case called Bernard, Mr. Justice McIntyre had an answer for this. And his answer was essentially, look, if you've managed to get yourself so drunk or so high that you are unable to attain the minimal level of mental acuity needed for a general intent offense, well then, just getting yourself that drunk or high is itself blameworthy. Now, this is a problematic line of reasoning because here, Mr. Justice McIntyre and Bernard appears to be substituting, as it were, the mens rea of becoming voluntarily intoxicated for the mens rea of whatever offense, general intent offense, the accused is ultimately charged with. And this seems to be, needless to say, a problematic line of reasoning, particularly given that there is no offense of voluntary intoxication as such. For his part, Chief Justice Dixon thought that all of this was seriously problematic on a charter level. By depriving the defendant of the opportunity to argue that self-induced intoxication negatived fault in the context of general intent offenses, effectively, what Chief Justice Dixon claimed is that this transforms general intent offenses functionally into absolute liability offenses. It makes it possible for criminal defendants to be convicted not because they actually had turned their minds to this or that risk, but because they simply lacked the opportunity to present evidence capable of casting doubt on that. But there was a further question left over after Bernard. We've seen already that Mr. Justice McIntyre justified the distinction between general intent and specific intent on the basis that, at least in the context of general intent offenses, one's decision to get that intoxicated or that high in the first place could, as it were, serve as a stand-in for whatever mental element was required by the offense in issue. But how far does that go? What if one is so intoxicated that one is actually incapable not just of forming the requisite mental state, but of engaging in voluntary action at all? Can this idea of transferred fault operate there too? Can it make, as it were, proof of voluntariness unnecessary? Well, as we're going to see in the next lecture, the Supreme Court ultimately balks at that idea